Y'all, just uh, we are gathered here today for this emergency meeting of the law nerds. I am now calling us to order. Point of order, can Brown still be KJ's lawyer? Now, Saltsy didn't file this motion. Brown did. We've got some shit to talk about. I've set our FFS system tonight to orange. I reserve the right to change that to red. I will ask you guys as we get through this if you think we should change it to red, law nerds, but look, there's a lot going on. This new motion, can Brown still be KJ's attorney? Who thought we would be here today? I sure didn't. We need to just get into it. There's a lot. We're doing a first look lawyer reacts at two new things filed in the Tati Westbrook without a crystal ball defamation lawsuit. We are now up to 64 docket items, and we haven't even gotten into this bitch yet. So let's go. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. Y'all, I did not see this coming. I appreciate that there's new filings. I just, this motion is not something I thought I would see, but as I did a quick scan, and as I started perusing it, I was like, oh, that's an excellent point. This might actually be a problem. This might actually be a problem for Brown. And, all due respect to Brown, normally shade comes after that, but there's actually not shade. There's normally shade after that, but this was like, hey, I see this as an issue. I'm going to bring it to the court's attention before Saltsy brings it to the court's attention, which is probably a good call because I imagine it probably would have come up anyway. So I'm like, all right, this is a good call. For those of you that need a road so far on the Tati Westbrook without a crystal ball defamation suit, first, I have a case brief video that's probably one of the shortest videos I've ever put out. Yes, it's still 25 minutes. We're a long content channel here. Long form content. But in October 2020, Tati Westbrook, YouTube beauty guru, filed a defamation lawsuit against Commentary Channel Without a Crystal Ball and its proprietor KJ. Then there was a motion to not delete your shit. That's been resolved. Awesome. I still think we're going to see stuff come up from that, but it's been resolved by the parties. They stipulated, they agreed. Then the defense, instead of answering the lawsuit, they filed a motion to dismiss, which is their right. The motion to dismiss was based on jurisdiction, a word that all of you are so fucking tired of hearing. You're like, jurisdiction haunts me in my sleep. I hear it in my dreams. Can it be in Washington? Should it be in Minnesota? Who knows where it goes? Jurisdiction. Who's the boss of this case? What state is the boss of this case? Then everything went off the rails. There were allegations. There was a declaration and then more declarations and then hacking and death threats and wildness happened. And then Brown filed a motion for sanctions against Saltsy. Saltsy and Brown had a conference with the court. I'm a little out of order. The court was like, y'all, sort it out. You're grown-ass lawyers. Knock it off. I don't want to plow through your emails of he did this to you and he did this to me and me. My interpretation of what the court said on the court call. The court was actually very patient on the court call and didn't go off on everybody. The court was like, stop it now. All of you stop. So then everything went off the rails even more. And now we're here with defendant's motion to qualify counsel to continue representation. Like, can Brown still represent KJ. That's what this motion is. That's what this motion is. That's what it is. What? So I'm going to do a first look. There is a 13-page motion. We're going to go through it pretty quick with a first look. And then there is a declaration from Brown again. There's another declaration. At this point, Brown's like a witness in this case. He has had so many declarations. At some point, at some point, before I hop into all of that, I do have to say, and I see friend of the channel, Octonation, in the chat. And I do want to say, it's not lost on me that today we like landed a rover on Mars, but people in Texas still don't have basic necessities like heat when it's freezing and water and food at the grocery stores. So I have been texting with the text crew that's in Texas. You guys have shared some very challenging stories with me, and I am sorry that all of you are going through it. So our thoughts are with you, and I hope that just talking about something else helps for those of you that do have power, and for those of you that watch this later. Our thoughts are with you. It's what's going on in Texas has been fucking wild, and I know other states are struggling too, not quite in the same way. Other states like Oregon are a bit more equipped for the cold and the winter than Texas is. So our thoughts are with you, and I am thinking about you guys. So in that vein, when I saw new stuff, I was like, you know what? Let's just talk about it. Let's just go live. Let's talk about it. Let's talk about it. Let's talk about it. Let's talk about it. So I'm going to go through these. I will get to chats and super chats and all the stuff after, and questions after. So you guys chat amongst yourselves, and I will be back to answer all the questions once we're done with the thing. Lori Smith, thank you so much for the super chat. She said, have a drink on me. And I saw one more. Uncovering hypocrisy. This is about Lorianne, but it's about whether he can still represent KJ because of what went down with Lorianne. So let's just, of course, the screen sharing's ready. No, it's not. No, it's not. And this, you will see, is not highlighted. Why? Because this is a first look. This was filed this evening. This very evening. All right, let's just make this a little bit bigger. I'm going to make this as big as I can so y'all can see it, which means it's hard for me to see the chat because I split screen. I've got a kombucha. I don't know what you guys are drinking. Hopefully it's something delicious. Let's just, y'all. Conference of counsel. This is a defendant's motion to qualify counsel to continue representation, meaning Brown is asking the court to continue on the case for a reason. So let's keep going. Introduction. On January 13th, 2021, plaintiffs filed the declaration of non-party witness Lorianne Barnhart again. In that declaration, Barnhart, 1, testified that on or about January 10th, 2021, the undersigned offered to represent her as her attorney for purposes of her response to a subpoena from plaintiffs. 2, suggested that such an attorney-client relationship was formed around that time. And 3, testified that she had some interest with regard to this lawsuit that was in conflict with the interest of the undersigned's client, defendant Paulson. This again goes back to the Lorianne declaration. There is an entire video on the Lorianne declaration. The Lorianne declaration has now come up. I feel for Lorianne at this point. She is probably so sick of seeing her name in this lawsuit. And she's like, I just tried to say what I knew, and now bleh. So we'll see. Defendants were concerned, KJ's, that plaintiffs included this testimony in the declaration to set up an argument to disqualify the undersigned and his firm from continuing to represent defendants in this matter. What that means is that Brown is saying, we thought that plaintiffs were trying to say that now there's a witness that you represent and you can't represent both. Here's the thing. If Lorianne is a necessary witness, which after jurisdiction, who knows, but now this declaration is at issue with regard to sanctions as well. So Lorianne might very well have to at some point testify. If Lorianne's a witness and has to be a witness, then Brown can't cross-examine her if he represented her in any way. So if there was any attorney-client relationship formed, he can't cross-examine her because the information that she would have given him, believing that she was a client or understanding that there was some relationship there at that time, he cannot use against her. And so he effectively cross-examine her? Maybe not. And I think that they will get into that more in this because that's what this is setting up. So defendants were concerned, and defendants have argued in other motions, one, that there was never an attorney-client relationship, and two, that there was not a conflict. And I didn't agree with that position that there was not a conflict, and I'll tell you why. Why I believed there was a conflict is because Lori Ann was saying things that, if true in her signed declaration, go against KJ's interest at this point of trying to get jurisdiction elsewhere. Lori Ann was saying, I was essentially an agent. I worked on behalf of and with KJ to do things for her and for her channel. And I live in Washington, and she knew I lived in Washington. Those things are against KJ's interest in the legal sense of the word, because KJ's saying no contacts with Washington. And Lori Ann's saying, I'm in Washington, motherfuckers, and this is what I did. And so that sets up an agency in Washington, which is against interest. So against interest of KJ means that there would be a conflict there. What's best for Lori Ann as a witness might not be what's best for KJ as a defendant. Lori Ann said in some of those emails, hey, I want to just turn over my information to Saltsy. That wasn't necessarily best for KJ at that time, though probably best for Lori Ann at that time, which is why I thought there was a conflict. Because it's like, look, Lori Ann was saying in these emails that we've gone over in other videos, I just want to turn over whatever the fuck Saltz wants to see. I don't want to be involved. I don't want to deal with this. Just let him have my Twitter. I just don't care. And then KJ's side was like, no, there's going to be a subpoena. It's fine. But at the time, that probably wasn't in KJ's best interest, depending on the amount of contact KJ and Lori Ann had in the DMs and what those DMs said, because we're still in this motion to dismiss for jurisdiction in Washington, and Lori Ann lives in Washington. So defendants were concerned. We already did that. I've said that like 17 times now. Accordingly, the undersigned arranged a meet and confer with plaintiff's counsel on January 27th, 2021. Ooh, we get to hear about phone calls. Goody. To discuss the matter and his plan to bring a motion to qualify to request that this court enter an order finding that no disqualifying attorney-client relationship was formed. Wait a fucking second, though. I have an issue. Brown argues in the motion for sanctions that there was an attorney-client relationship and that Saltz should be sanctioned for talking to Lori Ann because there was an attorney-client relationship. How do you argue 2 days ago in a motion that Saltsy should be fined sanctions by the court for the Lori Ann declaration because Lori Ann was represented, and then come in here and say, I want the court to find by order that there was no attorney-client relationship, but had already asked the court to fine Saltz based on an attorney-client relationship? How are we arguing both sides of this? You can't. As an attorney, you cannot go into court and argue blue, 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 and then 2 days later go, I didn't say blue, purple, 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 purple. You can't argue opposing arguments to the court. We're going to end up in some kind of like estoppel where it's like, you can't argue that because you've already said this. One of these can't be true. You can't argue opposing things. That's why there are opposing sides to argue the opposing things. One attorney can't argue both sides of an issue. It is or it is not. But you can't say it is for the purposes of sanctions, but it is not for this purposes. What? We're going red. We're going red on this. We have to. We have to up the fuckery level. We only got a page in and the fuckery level has to go to what the fuckery. Cause you can't do that, bro. Like, no. Just no. To the undersigned, and Brown's talking about himself. To the undersigned's surprised, in that call, plaintiff's counsel assured the undersigned that, and now we're going to get a response because now Brown is representing shit that was said on a phone call with opposing counsel. Oh my God. Counsel assured the undersigned that despite having included the above testimony in Ms. Barnhart's declaration, they did not see a potential conflict issue and had no intention of arguing for disqualification based on any such alleged attorney-client relationship. Well, there's not a conflict for Tati, and there's not a conflict for James, but there's a conflict for Lori Ann if she's a witness that has to testify. Based on that representation, the undersigned sought further guidance on the ethics issue. And determined that the motion to qualify could be obviated. I mean, gold star. I like obviated. If plaintiffs would simply confirm in writing that they represented during the meet and confer, what they represented during the meet and confer. The undersigned proceeded to repeatedly ask plaintiffs for that confirmation, but they repeatedly refused. Oh, there's footnote. There's a declaration from Brown. So that's what all this is. Initially, they explained that they wanted to reserve the right to move to disqualify if quote, it becomes an issue later on. Yeah, like if Lori Ann testifies. And, quote, if and when they learn more information. Like, is Lori Ann going to need to testify? The undersigned responded that, one, the stipulation need only repeat what plaintiffs represented during the call, that they have no current concerns that would cause them to ask for disqualification, and two, they could reserve the right to move in the extremely unlikely event that they learn new information that would give rise to such concern. Plaintiffs then shifted their position, stating that they do have concerns currently about a potential conflict based on what they knew at the time of the meet and confer, and therefore would not sign the stipulation. So Brown is saying that Saltz et al. Have changed position, and we only have his representation of that at this point. Defendants should not be forced to proceed under the constant threat that plaintiffs will choose some strategic time in the future to make the disqualification motion that they clearly hinted at in the Barnhart declaration, then clearly disclaimed on January 27th, and then hinted at once again. Didn't the court say, what I don't want to do is have like me. Yes, the court did say that. And this whole motion reads like, well, then they said this, and then they said that, and then they said this. But I understand Brown's point here in that he's saying, I don't want them to just drop it later. I still am not sure if Brown is like hired for all purposes or if Brown's out after the jurisdiction motion. I think Brown's really hoping that they win the jurisdiction motion and this all goes to Minnesota. But it feels like Brown is writing these because the writing on these is so different from some of the early filings. But, and then hinted at again when asked to commit to the position in writing. As such, defendants asked the court to rule now on the disqualification issue to give them some certainty that their defense in these proceedings or future proceedings in another form will not be disrupted by a motion to disqualify that plaintiffs are keeping in their back pocket. Well, I mean, I understand that he feels that way. Like at any time, they're just going to drop this, like, you can't represent her anymore. I get the feeling, but it would have to be like ripe. Like it would have to, by ripe, it would have to be relevant at the time. Like, oh, now Lori Ann has to come testify and you can't cross-examine her. So you can't continue on. Oh my God. Okay. I mean, the way he represents it, I get it. I get that it feels like plaintiffs are keeping it in their back pocket, but also like it doesn't matter until it matters because it only matters with regard to Lori Ann. So it doesn't matter till it matters. Summary of the argument. As explained in dockets 43 and 52, the circumstances surrounding plaintiffs were again. Again with this. All he wants at this point is to have this Lorianne declaration thrown out, and like maybe thinking that the court's just going to be like, you know what, fuck it, I don't want to have to deal with all this, throw it out. But that's not how federal judges work. Oh my god. Okay, here we are. The circumstances surrounding plaintiff's procurement of Miss Barnhart's testimony were highly unusual and highly concerning. Yes, you've filed it in a precipice, a 300-page declaration, and a motion for sanctions. I feel like we're in that scene in Legally Blonde where she's like, so you were in the bathroom. You didn't hear the gunshot because you were in the shower. So the reason that you didn't, like, when she over and over in the shower, that's where we're at, but with less Reese Witherspoon. However, even taking her testimony regarding an alleged attorney-client relationship at face value, the undersigned remains qualified. How? To continue to represent defendants for the following reasons. Tell me. I'm fascinated. First, disqualification is a drastic measure, fair, and the court must consider the danger of a motion to disqualify opposing counsel as a litigation tactic. Okay, fair, but also pretty early in this case. Plaintiffs' shifting positions on this motion only underscore this concern here. I'm ready to hear what the other side has to say about whether they're shifting. Second, the emails on which the declaration relies. Whose declaration? Because a lot of Lorianne's declaration, if I'm recalling accurately, which if you've ever gotten into a fight with me and I bring up things that you've done 6 years hence, sometimes I recall things. But if I recall accurately, the emails weren't the only heart of Lorianne's declaration. It was also phone calls, but okay. Second, the emails on which the declaration relies do not support a reasonable belief on the part of Ms. Barnhart that the undersigned offered to act as her attorney. But you filed a motion for sanctions saying that Saltz should be sanctioned because she was represented. So where are we with that? I'm going to have to pull that back up because okay. Third, even if the emails could reasonably be construed as an offer of representation, well, here's the thing. Attorney-client relationships can be formed, which is why we say no attorney-client relationship. We are not giving advice and things like that. Because he gave legal advice and said it's not going to cost you anything, I can help you respond to the subpoena. I can help you file this in court. There was guidance given. I understand it. Jesus. Ms. Barnhart's own testimony established that she rejected that putative offer. Indeed, she testified that she was suspicious and not comfortable with the undersigned acting as her attorney and therefore cut off all communications with, which could also be seen as firing him, but okay. Cut off all communications with the undersigned and proceeded to speak with plaintiff's counsel the following day. So then why is there a motion for sanctions saying that he shouldn't have talked to Lori Ann? You cannot have it both ways. You cannot tell the court in good faith that Saltz should be sanctioned for talking to Lorianne and then say Lorianne fired you or cut off all communications with you and then talk to Saltz, because then Lorianne wouldn't be represented by you at that time. That doesn't mean she wasn't represented by you before, because if she cut off all communications, that could also be seen as ending the attorney-client relationship, meaning anything going forward from that point is not an attorney-client relationship, but anything going back in time from that point was an attorney-client relationship. So how are you filing a sanctions motion and then bringing this? This is better taken for me than the sanctions motion. Just do this. Just argue this. Don't argue the sanction. You can't argue both. Which is it? And 45-line paper. Mark it on your bingo card. And I like an arguendo, even assuming these are arguments I like very much. Fourth, even assuming an attorney-client relationship was formed, these are the arguments that are so helpful to the court. So helpful to the court. So helpful to the court. Even assuming an attorney-client relationship was formed, Barnhart does not have an identifiable interest with respect to this lawsuit. No, but she does with respect to the motion to dismiss, because she is at this point a witness who has been talked about at length. Let alone any interest that might be prejudiced by the undersigned continuing to represent defendants, unless you tried to, cross-examine Lorianne based on information that you knew based on the phone conversations that she had, because you can't act in KJ's best interest and Lorianne's best interest, but you all know how I feel about this. Indeed, as she herself expressly and repeatedly recognized, her only connection to this litigation is as a fact witness with information that is relevant, if at all, only to the issue of this court's personal jurisdiction over defendants. Yes, but could still be called as a witness with regards to that. And is now brought into the sanction motion and could very well have to testify with regard to the sanction motion that Brown himself asked for oral argument on. He can't cross-examine her on the sanction motion about what was known and what was told, because he at one point may have represented her. Woof. Fifth, any confidentiality that would have attached to Ms. Barnhart's communication with the undersigned was waived by virtue of the declaration's express reliance on and characterization and mischaracterization, SAS, of those communications for the purpose of impugning the undersigned. Fair enough on that point, but you still have a duty to someone that was a client that Brown can't waive. Only Lorianne can waive, and I don't think she can waive that for the purpose of him cross-examining her, because she did speak to him in confidence, and she did tell him things in confidence. He filed stuff under seal that she had told him in confidence. We're still not at jurisdiction yet, you guys. Oh my God. Factual background. The communications between the undersigned and Ms. Barnhart. Ms. Barnhart initially made contact with the undersigned via email. Ooh, let's see how many emails it is in this motion. On December 24th, 2020, she explained that she understood the undersigned was Paulson's attorney and expressed concern about being harassed by plaintiff's counsel and abusively outed in the Fulmer declaration filed by plaintiffs, in which they expose irrelevant but very damning personal information about her. The undersigned responded to Ms. Barnhart as a potential witness, not a potential client, and began a series. Right, but okay. We're okay. I've said it. It's been said. Emily, you've said it. They know that even though you don't expressly make her a client, you can still offer legal advice, and that can create an attorney-client relationship. And she is a layperson, so it is not on her to determine that. It is on the lawyer to determine that. But we've said it. It's been said. Okay. Oh, all right. The undersigned responded to Ms. Barnhart as a potential witness, not a potential client, and that began a series of email exchanges and 2 telephone calls over the subsequent 18 days. The majority of the email conversations, which took place over like 6 different email addresses by the by, centered on Ms. Barnhart's agreement to sign a declaration, the first Barnhart declaration, which would be filed by defendants, the purpose of which was twofold: to explain the abusiveness of the Fulmer declaration, which, how is it relevant, but okay, other than to smack it salty. Sorry, that's part of this. And specifically, Ms. Barnhart's belief that she was deliberately outed in retaliation over a spat she had with plaintiff's counsel, Michael Saltz, in November 2020 on Twitter. And 2, to confirm defendants' statements that they did not know Ms. Barnhart resided in Washington, which would have been the biggest purpose. Barnhart helped prepare and edit the first declaration, we know. The undersigned and Ms. Barnhart also exchanged emails, we know, and spoke about plaintiff's subpoena, we know. The undersigned and Ms. Barnhart spoke on the phone on January 5th, 2021. I would like to know how long they spoke on the phone, because in one of the things it said like long time, 18 minutes, and I was like, Salt said he spoke to her for like 11 hours. So, okay. About the declaration and the subpoena, the undersigned explained that he was defendant's attorney and not hers. She told the undersigned that she already recognized this. See, and now he's going directly against what he argued in the motion for sanctions, like directly against. the motion for sanctions. And there's a declaration. Ms. Barnhart now relies on emails the undersigned sent her, sent subsequent to this call, to suggest that at some point he became her lawyer for purposes of responding to the subpoena because he said, I can help you. I understand that. In these emails, the undersigned provided general information and admonitions to Ms. Barnhart regarding responding to subpoenas and responded to some of her concerns, including her concern that she did not have the money or technical expertise to comply with the demand for electronic data from her social media accounts, the emails pertaining to the subpoena and other topics. Yes, she also said, I'll just go to legal aid. And he's like, it'll cost you nothing. I can help you. It'll cost you nothing. I've got... And the thing is, I wouldn't care about the attorney-client relationship this much if he was consistent in arguing there was no relationship here. If Brown was consistent, like there was no relationship here, cool. We'll talk about the emails and go back and forth. Like, could it be? Could it not be? How will the court determine this? But he's arguing there is enough of a relationship to sanction Salty, but not enough of a relationship for it to affect me. And I'm like, you can't have it both ways, which is where my annoyance is with this. You cannot have it both ways. Barnhart suddenly changed sides. Yeah, after KJ was like, I don't know her. The timing is so interesting. There are plenty of videos regarding that on other channels. I know Truth Sleuth has covered it. Drama and Opinions has covered it. I'm sure there are others that have covered that timing of when Lori Ann switched sides. But those two channels cover it particularly well. And Drama and Opinions has all the sassy editing. Miss Barnhart suddenly changed sides and completely changed her story on January 13th, 2021. Miss Barnhart's email to the undersigned late January 10th and continuing January 11th begin to sound confusing. No. Her emails say, oh, I see how it is. I don't think Brown's watched KJ's video where she says that Lori Ann's not a friend. I don't think he's seen it. Those emails aren't confusing in context. She's like, oh, I see now. I understand. I see who's being played. Goodbye. You're dead to me. Tell Cersei it was me. Those are those emails. And appeared to reflect an increasing level of anxiety. I agree with that. And even despair over the harassment and intimidation she has been subject to at the hands of plaintiff's counsel. I see why he frames it that way. I don't necessarily agree with all of that. She was definitely frustrated, and she seemed frustrated to me. And you can go back and watch that video, but she seemed frustrated to me that the right Lori Ann, wrong Lori Ann thing hadn't been fixed. And she seemed frustrated that she couldn't just turn over her information. She's like, I don't understand why I can't just give this shit to Salty and just fucking be done. Just give it to him. Tell the court it's the wrong Lori Ann and that they put this other woman's work information out there and just let me be done. And it seemed like Brown was maybe holding Lori Ann in his back pocket for a gotcha moment at Salty. And it backfired because his client, in my opinion, went on video and said, Lori Ann and I aren't even friends. I barely, like, Lori Ann who? Like, we don't know her. And Lori Ann was like, oh, I see. And then the declaration came out and Lori Ann was like, oh, we don't know me. I see. I see who it is. I see who's being played. The next day, plaintiff's counsel interviewed Ms. Barnhart for 11 hours, prepared a different declaration for her to sign, and procured her sworn signature to it. They did this with the knowledge that, one, Barnhart believed she was represented by the undersigned. Or did she think she had fired him in the email where she's like, wait, didn't he say it? He said it in an email here that she said she was never speaking to him again. It's like a page up. She therefore cut off all communications with the undersigned. That would be terminating him. Okay. There are some things that are just... Okay. That are just facts. That are just facts. The next day, plaintiff's counsel, 11 hours. Barnhart believed she was represented by the undersigned or believed she had fired him because she cut off all communications and was like, tell Cersei it was me. I'm not talking to you anymore. She was eager to swear under oath a week earlier to an entirely different and nearly perfectly contradictory version of events. I agree with that. But also, then there was a video. And so The one that's sworn is the one that's sworn. Everything else is not sworn. So everything else is not under penalty of perjury. The 150 emails exchanged between the undersigned and Ms. Barnhart over the previous 18 days were perfectly consistent with the first declaration and 5 different email addresses, which she was eager to sign under oath and contradicted the testimony they were putting in front of her in the second Barnhart declaration. I mean, until she signed that she was uncomfortable with it and didn't want to sign it and then didn't sign it. But okay. She admitted to them to being confused and unable to remember things well because of medication and anxiety. I worry that this is some of the stuff that they put under seal and he's blasting it in multiple declarations, which if that's the information that's under seal, it's just a dick move and I don't like it. After the second Barnhart declaration was filed, the undersigned came into possession of information strongly suggesting that Ms. Barnhart was not aware of what she was signing when she signed it. In the second declaration, Barnhart states that the undersigned became her attorney at some point with respect to her response to plaintiff's subpoena. The circumstances surrounding the preparation of that declaration and Ms. Barnhart's state of mind when she signed it provide strong grounds for this court to disregard that testimony. Boom, there it is. That's the point of all of these motions. However, as explained below, even taking the second Barnhart declaration at face value, which you have to because 1, it's signed, and 2, on a motion to dismiss, all the facts go in favor of the non-moving party in this case being Tati Westbrook. So if there's a discrepancy with Lori Ann, the discrepancy errs in favor of Tati Westbrook. We still aren't at jurisdiction yet. Balls. Argument. Disqualification is an extraordinary and disfavored remedy. Fair and true. An attorney-client relationship never formed between undersigned and Ms. Barnhart. Then don't ask for sanctions based on there being an attorney-client relationship. The emails between the undersigned and Ms. Barnhart did not convey an offer to form an attorney-client relationship with respect to Ms. Barnhart's subpoena response. The court's going to have to decide the facts on that one and be like, was it or wasn't it? That's totally proper for the court to be like, I don't know. The January 10th, 2021 email. The January 10th, 2020 email. Ms. Barnhart wrote to the undersigned on January 8th. Wait a second. Okay. On January 8th, 2021, explaining that plaintiff's counsel's harassing conduct had already caused her severe anxiety and that she may just ignore the subpoena altogether. The undersigned attempted to respond in a manner that would calm Ms. Barnhart's field and dissuade her from simply ignoring the subpoena, which was to give her advice, I think is what's coming next. This is what led to the undersigned on January 10th to write the sentences on which Ms. Barnhart's declaration now relies. I recommend that you sit tight, accept service if they come to your door, and then we can take it from there. You are not in any trouble. I think there were more statements than that in the email, but okay. In her declaration, Barnhart states, such statement confirmed to me that I apparently was a client of Mr. Brown's, in that I understood his statement to mean that he was inserting himself into my situation of having to respond to the subpoena. And he said it won't cost you anything, but okay. It is difficult to know what it means to say that an email confirmed that something was apparently the case. That is a good point. I don't know if Brown's one to cast besmirsions on saying things like apparently and because he makes a lot of statements, but it's a fair point. Oh, there's a footnote. Plaintiff's counsel prepared this declaration. Which plaintiff's counsel? I'm curious. Presumably with the knowledge of the applicable test under Washington law governing the existence of an attorney-client relationship, yet for some reason they decide to include this vague and ambiguous testimony. Is he arguing, y'all? Hypothetical? Is not hypothetical, but just, is he arguing? I think he's arguing that they were using the Lori Ann declaration to try to get him disqualified, which is an interesting argument because it didn't even stick out in my mind until later that I was like, oh, that could cause a problem. Because when I first read the Lori Ann declaration, it was like, oh, they're going after Brown to call him out and say, you did this, you did this, you did this. I didn't read it with the intent to disqualify. It seems that Brown did. That's very interesting. I wonder what the response will be on this, because they are reading into this. This is them playing chess and setting up the pieces on the board to disqualify me as counsel. That's how he read it. I don't know if that's how it was meant, but that's how he read it. And that's very interesting. Barnhart explained that undersigned's email apparently confirmed an attorney-client relationship because she understood Brown's statement to mean that he was inserting himself. Okay, we got the footnote on that. Where to the extent any meaning can reliably be discerned from that odd phrase, said the man who wrote that there was a murderous conspiracy in the motion to dismiss, but okay. It is not a fact or circumstance from which a person could plausibly conclude that an attorney-client relationship had been formed. He is leaving out all the offers to like respond in court for her, but I get why he would leave those out. Indeed, it is perfectly consistent with defendant's position that the undersigned involved himself simply by providing and offering general information and assistance regarding responding to a subpoena. The thing is, it's already been discussed in other court documents, and I wish he would just address it. It's already been addressed in other court documents that he also said, I can help you write a declaration. It will cost you nothing. I just wish he would address that part of this too. Oh, here we go. Yay! Here it is. It's here. Look, it's here. It's here. We're getting to that part. Huzzah! Huzzah! It's being addressed. Oh, I was worried. We were just going to go through without it. Yay. The second email from undersigned on which Ms. Barnhart relies is dated January 11th, 2021. Are they both dated January 11th? Oh, that's January 10th. Okay, fair. This email was in direct response to Barnhart emailing the undersigned the following message. I am not going to go to court. I have no money. I don't know how to download everything on my phone, so it won't be done. The undersigned responded shortly thereafter. The portion of that response on which the declaration relies states as follows. You don't need to spend money or hire a lawyer to respond to the subpoena or file a declaration. I'd like to stand up for you by filing your declaration if you'd let me. It costs you nothing. See, I'd like to stand up for you by filing it is kind of an offer to help. Ms. Barnhart characterizes this as a, quote, offer to represent me at no charge in responding to said subpoena. However, in context, this is clearly not an offer to represent Ms. Barnhart as her lawyer for free. It's not. Y'all, I want to know. Do you read it the way Lorianne said she read it in the declaration, or do you read it the way Brown is saying it? You let me know. You don't need to spend money or hire a lawyer to respond to the subpoena or file a declaration. I'd like to stand up for you by filing your declaration if you'd let me. It costs you nothing. What do you think? Chat, what do you think? Oh, Creepshow, welcome. Brown is fighting to still be KJ's lawyer. It's very interesting. The undersigned's intent in writing these sentences in response to Ms. Barnhart's concern was to assure her of two things. That I was her attorney, maybe. I want to know what you think. First, that the undersigned wanted Ms. Barnhart to understand that she did not need to spend money to respond to the subpoena, for example, by paying to have data retrieved because she did not know how to do it, offering to provide general information to a witness regarding the logistics of gathering electronic data from a smartphone or personal computer is not the sort of assistance that constitutes legal advice, okay, or supports that witness's subjective belief that an attorney-client relationship has been formed. But that's not what that says. Second, the undersigned wanted Ms. Barnhart to understand that based on what she had told me, she did not need to be represented by a lawyer at all in the proceedings, the process of responding. I'd like to stand up for you by filing your declaration if you'd let me. I understand Brown's point, but I understand where there could be reasonable confusion. What I don't understand is after 100, okay, So Brown is arguing after 150 emails that this email comes at the end of the chain, that Lori Ann is not supposed to understand that he might be offering to represent her. After all of that conversation, I just don't know. Second, the undersigned wanted Barnhart to understand. We got that. Even if Miss Barnhart had a reasonable subjective belief that the undersigned offered to be her attorney, Barnhart's own testimony proves she responded by rejecting that offer. That is a good argument. I appreciate, out of all the things that have been said, this one we like the most so far. After describing the above email passage as forming an offer to represent her, Barnhart testified that she, in effect, rejected the offer. She explained that 1, she was very suspicious of Brown's motives in offering to assist with the subpoena. 2, she was not comfortable with having Brown controlling the production of her documents or other evidence. 3, she did not feel comfortable with Brown's offer of representation. And 4, was concerned that there would be a conflict of interest representing her and the defendants. So now we believe the Lori Ann declaration? Because Brown has spent all of his time saying we can't believe the Lori Ann declaration, but this part of the Lori Ann declaration is to be believed. But if this part of the Lori Ann declaration is to be believed, then all of the Lori Ann declaration is to be believed. And if all of the Lori Ann declaration is to be believed, then she believed there was an attorney-client relationship and that she terminated it when she stopped talking to him. But also, if he believes that he didn't represent her, why file the sanction motion saying that she was represented? Why? Because all of this would be taken better for me if Brown was saying, I have said this entire time I didn't represent her. Salty tried to besmirch me by saying that I did. He's a dick. He's wrong. I'm out. But then you can't turn around and file for sanctions saying she was represented. You cannot do both. And in fact, Ms. Barnhart did cease communicating with the undersigned on January 11th. So either she terminated the relationship on January 11th or no relationship existed. And if no relationship existed, see what I just said, refer above to what I just said about the motion for sanctions. Even assuming an attorney-client relationship was formed, Rule of Professional Conduct 1.9 is not implicated here. Ms. Barnhart has no interest materially adverse to defendants. I disagree. Ms. Barnhart's suggestion of the formation of an attorney-client relationship potentially implicates RPC 1.9a. The rule provides that a lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client unless the former client gives informed consent confirmed in writing. What that means is Lori Ann would have to say, yes, you can go ahead, and KJ would have to say, yes, you can go ahead. The thing is, there can be conflicts within this case if Lori Ann becomes a witness, because Lori Ann as a witness, it might be in Lori Ann's best interest as a witness to throw Brown and KJ under the bus. This is hypothetical conjecture of a situation. If the situation is that Lori Ann gets roped into either a hearing with regard to jurisdiction or a hearing with regard to sanctions, Lori Ann's truth might be, they tried to get me to say I don't know her. And that wasn't the truth. That is directly not in Brown or KJ's best interest, but that might be in Lori Ann's best interest. How could Brown cross-examine her on it? Okay. Brown and I are going to disagree on that point. First, the only indication of an adverse interest is in the form of vague assertions in the second Barnhart declaration as set forth in detail. That declaration lacks any evidentiary value except it's a signed declaration because of the circumstances surrounding its drafting. Oh, okay, Salty did things wrong, so you can't rely on it. But literally 3 sentences above, he relies on it as value. How do you argue in the same document that the declaration lacks evidentiary value, but if you rely on the document, it absolves me of all the things you're saying that I do? Second, the only interest even hinted at in the Barnhart Declaration is Barnhart's alleged possession of information that contradicted the testimony of Paulson. Right. That would put them at odds in the same case, especially if it came up that there was ever a motion with regard to perjury where Lori-Ann's saying, no, what, and she said this in her declaration, no, what KJ said in her declaration is not true. Lori-Ann could very well be a witness at a perjury hearing if that ever came up, saying, no, what's in that declaration, I have knowledge that it's false. And then Lori-Ann would be, again, a witness. I hope that doesn't happen for anybody, but it could. Because she says in the declaration that there's stuff in KJ's declaration that's not true, and those KJ declarations are sworn under oath, but okay. As explained at length in docket number 43, that information is contradicted by what Barnhart repeatedly said and wrote to the undersigned. So we're to believe again believe Lori-Ann what she said to me, don't believe Lori-Ann what she said to Saltz. Fine. Barnhart's first story was plainly consistent with defendant's interest. Yes, that is the most true thing that is said. The first story was consistent with defendant's interests, which means if that was not true, if that was Lori-Ann riding for KJ to try to help, then Lori-Ann saying not that is at odds with defendant's interest. If the second story signed under oath is the truth, then that is clearly at odds with KJ's interest in this case. It's in the thing. That's where the diverse interest is. Right there. He wrote it. That is the different interest. It would be unfair to defendants and the undersigned to permit plaintiffs and her Miss Barnhart to create a disqualifying conflict by suddenly changing that story 180 degrees. She changed the story and signed it. It wouldn't be changed now. It's already been changed. It's already been signed. Oh, God. That sentence, what are we at? Line 15 and 17 because it's not spaced properly. That sentence. That's the one. Miss Barnhart's first story was plainly consistent with defendant's interest. And since her second story is 180 degrees contradictory, then that second story signed under oath is plainly at odds with defendant's interest. Materially adverse would be another way to say it, especially if it came down to what I'm saying is that what Lori-Ann is saying is that KJ said something untrue in a declaration. Materially adverse. It's right. It's right there. The research attorney in this case, God love the research attorney in this case, but the research attorney in this case, their head's just going to pop off. It's just pop right off. Pop right off. It would be unfair to defendants. Yeah, true. It would be unfair to create a disqualifying conflict, but if that conflict exists through your own emails, then they didn't create it. Either way. Third, even if Miss Barnhart was in possession of information that would be somehow damaging to defendants, like the fact that she's saying defendant lied in a sworn declaration, that would be damaging, I would think. That would not give her a material interest that could be jeopardized by the undersigned. Hey, it binged. Thanks, y'all. Some of y'all must have subscribed. Thank you. Do the YouTubey things. That would not give her a material interest that could be jeopardized by the undersigned continuing to represent defendants in this matter. But if your attorney cannot cross-examine a witness against you, I don't know how you could continue. Indeed, Ms. Barnhart repeatedly told the undersigned that she had no position with respect to the claims in this litigation. True, she has nothing to do with the actual defamation and everything to do now with the fact that she signed a declaration saying KJ lied in a declaration. That is a big deal. She also talks about mass flagging, which could be a big deal with YouTube. There are things that there is some stuff there. I want to say if there's smoke, there's fire, but I'm still scarred from last night's Real Housewives of New Jersey. Okay. Indeed, Miss Barnhart repeatedly told the undersigned that she had no position with respect. Right. Lorianne doesn't give a fuck about the defamation. I feel you, Lorianne. She explained she was just caught in the middle. But now we're relying on like this part's true. This part of the declaration's true, but the other part's not true. The back and forth on this is killing me right now. I have no basis to judge those legal claims in this lawsuit, and I have no interest in the Westbrooks before or after this lawsuit began. I have never had any interactions with Tati Westbrook or her family. I've never tweeted anything about Tati. Isn't this about Tati and her harassment? ? These are all things from Brown's declaration, so we'll get there in a minute. Moreover, to the extent Barnhart actually had such damaging information, and had an interest in disclosing it, she has already done that when she gave plaintiff's counsel access to her emails and social media accounts, allowing them to review everything therein, apparently with no constraints and no supervision. Ms. Barnhart clearly waived any confidentiality with respect to her communications with the undersigned RPC 1.9. I think that that's true. I agree with that because she turned it all over. She waived confidentiality, but that doesn't mean Brown's off the hook if she became a witness that needed to be cross-examined. But I agree, she gave all the information to Saltz and was like, he doesn't represent me. But it doesn't mean that Brown doesn't owe her a duty if she's still a past client. But I agree with regard to the confidentiality, which is why I'm skipping it, because yes, agreed. Conclusion: for the foregoing reasons, defendants respectfully request that the court enter an order finding that no grounds exist to disqualify the undersigned or the law firm. So he's asking on his own, of his own motion, he's asking of his own motion that the court again make a finding of fact in this case. Jurisdiction has not been decided. He's again asking the court, take the reins and say that it's cool. Say that I'm all right. Say that you're not mad at me. Say that I can still represent KJ in this case. But the court, he's still saying, I don't think you have the right to tell us what to do, but tell us what to do with regards to this. It's very interesting to me. Let's pull up his declaration real quick. It's probably going to read largely the same as this. And then I'm going to answer questions because I'm sure y'all have them. Because the ones I can answer, because I have questions. The back and forth arguing out of two sides of the mouth, it's going to be a problem. It's going to be a problem. It just is. It just is. Hey, also, 6,700 Law Nerds, what's up, y'all? Happy to have a ride. As I'm changing over, tomorrow night, I will be live for Friday Night Live, and I have a friend coming in. We're going to be talking about influencers being admitted into SAG-AFTRA, which is the actors union. He is an actor. He has been on things like City Guys and in The Mighty Ducks. He has acted as a teen. He has acted as an adult. He's a voice actor for a bunch of stuff that you know, even though you don't know, you know. And we're going to talk all about the business of being a creator. We're going to have a little creator chat and then talk about the SAG union and how that works. We talked about that on Tuesday's Coffee and Kersey. And then we have a fun little court of public opinion, which is why I wanted to ride on this tonight. Normally, I would have just saved this for Friday Night Live, but I'm really excited to have that creator chat with him. So I'm super excited to have Scott White on the channel tomorrow. And I didn't want y'all to be like, but we need to know what happened in the new documents, because I feel you. And I was going to read them anyway. And I don't want it to overshadow that conversation that I'm really excited to bring to you guys. So tomorrow night, that's what we'll be doing live. Let's get into Brown's declaration. Is this like the 4th or 5th declaration from Brown? I think so. I think this is it could be the 5th or 6th. It's a lot of declarations in this case. I'm like, Brown is basically a witness at this point, which he doesn't want either. Like, as an attorney, you never want to be a witness in a case. But here we are. All right. I am Brown. I am lawyer. I am not a cat. I am here live. It was a joke. It's not in here. That's why it's up on screen. It's not, it doesn't say that. And isn't I am not a cat what a cat would say. But anyway, Ms. Barnhart and I spoke on the phone January 5th, 2021 about the declaration we would prepare for her to sign, and subpoena plaintiffs indicated they would serve her but never did. Yeah, because she gave it to them. That's why they never served her a subpoena. She gave them what they were going to subpoena. During that call, I want to know how long that call was. During that call, we discussed the fact that I was defendant's attorney and not hers. She told me she already recognized this. On January 11th, my email said, we've already gone over it. I'd like to stand up for you. Whoa. My intent in writing these sentences in response to Barnhart's concern was not to offer representation. This was all in the motion. After the second Barnhart declaration was filed, I was concerned plaintiffs were setting up an argument for disqualification. Accordingly, I arranged to meet and confer. That was all in the motion. I proceeded to repeatedly ask plaintiffs for confirmation. They repeatedly refused. So really, he just wrote his entire declaration into the motion the exact same way. Cool. Initially, they explained they wanted to keep open the possibility of moving to disqualify if they learned new additional information supporting such a motion. I mean, it's fair because you don't know till you know, right? You don't know till you know. You can't. Sometimes conflicts don't present until something happens, and it's like, oh, now this witness came up, like the motion for sanctions. Oh, that happened. Now this happened. Now we have to have a conversation about it because you don't know. Now you know. All right. I responded by explaining that I only needed a stipulation based on information they currently knew. I imagine that no attorney's inclined to do that, especially after the interactions these attorneys have had. Oh, that's the end. Oh, sweet Jesus. There we go. Yay! Good. Fantastic. Exhibit A. Oh, let me look at Exhibit A. I haven't perused this. I see email addresses. Hold on. Let me look at Exhibit A real quick. These are the lawyer email addresses. Okay. I have looked further into the matter of disqualification since you informed me last week that you have no intent to challenge my ability to continue as defendant's counsel based on Lori's statements in her declaration. I believe that under these circumstances, the motion to qualify can be obviated by a stipulation confirming your intent in that regard. I would like to proceed in that manner. I am attaching a draft stipulation for review. Please let me know if you're willing to stipulate. Let me make sure there's follow-ups. This is from co-counsel, Washington counsel, local counsel for Tati Westbrook, Blanco. Hi, Michael. I don't believe there is anything to stipulate to in this instance. Even if we did stipulate to such a motion, I don't feel like we should be precluded from raising an issue if one becomes an issue later on. I have never been asked to stipulate to someone being qualified to represent a party, so I'm not sure why that is necessary in this instance. Jeffrey Blanco coming through with like, why is this a thing? Why is this a thing? Why are you asking for this to be a thing? All right, Brown's response. Ooh, I love it. I'm fascinated by all the attorney back and forth emails. Normally you never get to shit. You never get to see any of this shit. So I'm fascinated. We're going through all the emails. Let me provide more context for why I think I need to file a motion. All of this should just be a phone call. To qualify or get your stipulation. You prepared a declaration for Lori Ann, in which she appears to say she doesn't appear to say it. She says it. She appears to say she believed I was her lawyer. You claim she said that to you when you made contact with her around January 12th. You also said in her declaration that she had some interests that conflicted with Katie's interests. Oh, that's an interesting turn of phrase. That's odd because it's not we're not dealing with multiple Katies. We're dealing with a Lori and a Katie. If it was two Katies, I would see it's like your Katie and my Katie, but that's an odd turn of phrase to me. You also said in her declaration that she had some interests that conflict with my Katie's interests. That's odd. By putting that in her declaration, you were suggesting that there is a conflict with me proceeding to represent Katie and without a crystal ball. Also WOACB, which without being one word, it should be WACB. 2 R's. It's like 2 R's. I can't just proceed with the threat hanging over my head that you will move to disqualify me. You clearly indicated on our call that you have no intent to do that. I understand that. If you will commit to that in writing, I do not need to bother the court with the motion to qualify. This just is my Katie weird to you guys? Is it me? Am I weird? Is that weird? I need to chat. Is that weird? It feels weird to me. Let me know in the chat or in the comments. It feels odd. I've never referred to a victim in a case as mine. Like, ever. Hi, Michael. I think it is important to distinguish between what Ms. Barnhart states in her declaration and what I have said. I don't think you can attribute statements made in her declaration to me or any of the lawyers for plaintiffs in this case. That being said, I don't know what relationship actually existed, if any. So asking me to stipulate to the existence or non-existence of a relationship you may or may not have had with a third party seems to put me in a tough spot. I don't know if this is an issue or not, and I don't want to waive my right to raise this issue if and when I learn more, which is why I stated that a stipulation from me now may not be worth anything because I would reserve my right to change my mind if when more information becomes available. Jeff. Okay, Jeff. I mean, it's I can see his point too, because I wouldn't stipulate. I'd be like, look, I don't know what the situation is. I wouldn't stipulate to it either. Thanks, Jeff. I love that Belanco calls Michael. He's not like, hey, Mike, what's up? What did Katie say today? It's just so the difference between the two attorneys is kind of funny to me because it's like, hey, Michael, Miss Barnhart. And Michael's like, yo, Jeff, what my Katie said was Lori doesn't be represented by me, but we're good. Okay, bro, cool. It's just so interesting to me. I'm going back to look and seeing if, Belanco does not call any of the parties in this case other than hello, Michael, or hi, Michael, by their first name, where Brown definitely does. It's interesting to me, the difference between the two. Okay, back to hi, Jeff. Thanks, Jeff. What I want is simply a stipulation reflecting what Michael said on the call. You have no current concerns that would cause you to ask for disqualification. If not, I'm not asking for you to waive any argument that might arise based on information you discover in the future, although I cannot imagine what that would be. I've revised the draft stipulation to clarify. Please let me know if this is acceptable. Didn't the court say that exactly what the fuck she didn't want to do was to go back and forth between emails of he said this and he said this and they said this and they did that? I feel like that's exactly what Babs said on that conference call. But isn't it fun that we all get the emails? We get a sense of the personalities in this lawsuit a little bit more from going through their email exchanges. This will all be very helpful when this is made into some kind of a Netflix original, because we actually have a little bit of the personalities because we see the way they write their emails. Hi, Michael. Not hey, Mike. I'm waiting for Jeff to be like, what up, Mike? This is what we're doing. Hi, Michael. That is not my recollection of what was said during our call. Oh. Oh dear. My recollection is that what we represented was that we didn't intend at that time to make a motion to the court on that issue. I do have concerns about this issue. The scope and parameters of any relationship or lack thereof you may have created with Miss Barnhart. See, he doesn't call her Lori. During your communications with her is not something I am prepared to stipulate to, nor do I think that a stipulation to not raise the issue now while reserving my right to do so later is of much use, right? It's a waste of time is what he's saying, and I understand that argument. I'm not sure what the motion is that you intend to bring before the court. It is your intention to ask the court to make the finding of fact that there was never an attorney-client relationship between you and Ms. Barnhart. If so, I don't believe I have ever seen such a request to the court in this context. I don't think that my stipulation would have any bearing on that determination. And that is the end of that. That is it. That is all of the emails. That is all of the emails. That is all of the emails. It's interesting to me in this email that what is said is that is not my recollection of what was said during our call. That is not my recollection of what was said during our call. My recollection is what we represented was that we didn't intend at that time to make a motion to the court. So in this email that is attached as an exhibit, you have local counsel in Washington stating that the phone conversation is not what Brown thinks it is. You have now Blanco saying, what you think was said on that call is not what we said on that call. What we said, Brown represents in this whole motion, what they said on the call was they're not bringing it. Jeff Blanco, poor Jeff now needs a name. Jeff has gotten dragged onto the channel. Jeff is local counsel. Jeff has said, that's not what was said during our call. I recall that we represented to you, we didn't intend at this time to make a motion on this issue. That's not what Brown said in the motion. Well, at least we have all the emails. You guys can decide. Y'all can decide. Let's get to questions. I know I've missed super chats. I'm going to go through and try to catch them up. I want to see what you guys all think of Brown referring to Jeff as Jeff, Lori as Lori, and Katie as my Katie. Because, oh my. My Katie sounds like Scarlett O'Hara's dad, my Katie Scarlett. Yes, those are work numbers. And yes, if I need to go back and blur them out, I will. Those are work phone numbers. So yes, I love seeing the emails too. And the attorneys putting information in their footers are generally their work information. Not that I would expect anyone to start calling up these lawyers. Thank you. But yes. Hey, Jeff Dog, what's up? Jenny, that's how it reads. That's how it read to me. What up, Jeff? This is what Lori said. Katie said, Lori said. Hello, Bridget. Stay safe in Texas. Maybe sometime in transit space, maybe a typo. If not, it's weird AF. This is why I asked you guys what you think about the my Katie, like casually being thrown into that email. It feels really fucking weird to me. It feels weird to me. My Katie reads like he may have initially wrote my client and then changed it to Katie, but for clarity, but missed removing the my. It's totally possible. It just feels weird to me. But it is. It's totally possible. Yep, Brooke. Yep. You guys, this is just wild. Mr. Brown, sup, salty. It's just wild, you guys. Question, who would possibly not keep Brown on the hook dangling that they might take him off of at any time? Seriously, he's capping the paranoia from KJ, bilking already Blanco is already 17 steps ahead. Blanco said, look, Blanco essentially said in those emails, it's not ripe yet. It's not the time because once again, conflicts can happen when they happen. And if Lori Ann has to come testify, then it's a thing. So will the real Mike Katie please stand up? Katie, that is fantastic. It's kind of funny. It just feels weird. Jeff is really over it. Yes, Jeff is absolutely over it. Yes, it's absolutely yes. Question, I'm a little under an hour behind. Yes, I've been talking forever, but I'm curious, is there ever a reason to use 45-line paper? I don't know any courts that still go single-spaced. So in my opinion, no. There might be some jurisdictions that require it by local rule. I've never practiced in any, but the court has a standing order, so you just follow what the court says. That's my thought on that. Question, can Babs put a stop to this runaway train? The thing that's so difficult is that the attorneys have a right to make a record. So once Brown throws shit out there like this, the attorneys have a right to respond. And I thought Babs said, I don't want to be going through emails. There is a subreddit that has the transcript of the call up. I think it's the Without a Crystal Ball subreddit. I will link it. I'm making a note. Link subreddit. That has a transcript if you guys want to read that call. But she says, I don't want to be going this back and forth with emails. And where are we at again? Back and forth with emails. Amy, yeah, I feel like Jeff very clearly stated his position of this has no point. This has no purpose. We're not just stipulating to stipulate to something that we can't stipulate. A stipulation is generally the attorneys saying, we agree. Like right now, there's two stipulations on the record in this case. One of them's regarding discovery. We agree, both sides. We're not going to start discovery until we decide jurisdiction. We all agree. The only exception to that was to subpoena Lorianne's stuff, and that is resolved. Lorianne's like, here's my stuff. Then there is a stipulation to not delete your shit. Hey, we agree that there's this obligation and that there's this obligation. So those are the types of stipulations. We agree and the issue's resolved. But stipulating in this case, Polanco is saying won't resolve the issue because the issue's not resolved because we don't know if it's an issue yet. Like you can't resolve the issue before the issue arises. It's not Minority Report. You can't see the future. And this could be an issue, so I can't agree with you that it's not an issue, is essentially what he says. All right, there are many, I'm sorry, super chats that I missed. I'm trying to go through them real quick. I pulled them up on the back end I think. Let me see if I can get them on the back end of my channel so I can see them real quick. And thank you guys for them and answer some questions because I am trying not to miss stuff as I go through. So Natasha said, let's see if I get caught up on the chat. Natasha said maybe Brown gets aroused by the judge admonishing Salts, or maybe he wants to get admonished. Natasha, I don't know. Kyla said, my Katie sounds strangely possessive personal for a professional relationship. Same. I would also wonder why he wouldn't just say, Miss Paulson and Miss Barnhart. It struck me in the other ones that there were first names used, but it did. It felt overly familiar to me too. Beth, I read it and I was like, yeah. I didn't like it either. Snowcat Trish said, speculation. Do you think it's possible Brown is creating chaos so he can exit this clusterfuck? There's attorney ethics though. And that wouldn't, I don't want to believe that any attorney sets out to be unethical. I just don't. And I'm not saying that that's what's happening here. Creating an intentional clusterfuck to get fired by a client, in my opinion, poses ethical issues. I don't understand the play here. It feels like throwing money in a trash can and lighting it on fire with all of these motions and creating issues that aren't yet issues. I understand why Brown wanted to bring this up. He sees an issue. There is a potential issue here. He's not wrong. But if you know you're bringing this issue up, don't argue in a motion for sanctions days before that there was a relationship and then turn around and say there's not a relationship. If you know that this is like in your lawyer brain, if you know that you're bringing this motion, don't bring the motion for sanctions. Motion for sanctions can happen anytime. Wow. I just don't. Donald Duck says, I claim you as mine, Emily. Accept it and be happy. I am now. That's very funny. Thank you, my Donald Duck. Laura Ferris said, this feels like telling mom you hit your sibling before they can tell on you. Yes, Laura Ferris, that's what it feels like. He did this and he did this and he did this. The Gutless Warrior said 1.8K likes and over 6,000 watching. Hit the like button. Thank you for the reminder. I have not asked for the YouTube things. Go ahead and do the YouTube things, the likey, subscribey things. Do the things. I'm going to get back to questions in a second. Kittrall said, stand up for you. If he had said the same without the phrase, I could see where I could see it as standard part of KJ's defense. With that phrase, though, it sounds like he's offering a relationship. This is killing me. I get it. Thank you guys for the super stickers. I see them. Living Sweetly says, using a person's mental health status issues to get an edge is wrong on so many levels. One can now buy a face mask shaped like a pair of testicles. The perfect gift for kind of the D-bags in your life. That's funny. I didn't know you can get a testicle face shape mask, but thank you, Living Sweetly. Creep Show said, I just woke up. Yes, I saw that one. Octonation, thank you for the super chat. Allison said, question, other than the hand slap that the court gave previously, can Brown be disciplined for this type of behavior more than a stern talking to? If A, there could be a motion, but B, the court could admonish the attorneys with regard to this. Dr. Riley, Emily, you need a spa day. Hope this helps. Thank you. Donald Deck, thank you for the other super chats. Exercise gives you endorphins. Endorphins make you happy. Happy people just don't shoot their husbands. They just don't. Thank you for the Legally Blonde quote. I appreciate it. Phoebe asked, if your attorney does a terrible job representing you, can you sue them? In certain circumstances and situations, yes, you can. It's very difficult. And if you want to know all about that, about clients not getting properly represented by attorneys in one way or the other, follow all my content on the Girardi case, because that's what we're doing. Pierce said, is this not perjury on Brown's end? It'll be interesting to see if it is improperly arguing to the court. I imagine Brown's argument will be, well, I'm arguing in the alternative. It doesn't read that way to me. It doesn't read that way to me at all. Lori Smith said, have a drink. Thank you, Lori. I think that got to almost all of the super chats. I appreciate you guys. I try to get to them when I miss them the best I can. Could Lori come out and say that she lied to Brown or would that destroy her credibility? She didn't swear anything to Brown. What you put in an email is not a sworn declaration. What you say on a phone call is not necessarily sworn either. The time when it becomes a sworn statement, this is my truth, Scout's honor sworn statement, is when you sign it under penalty of perjury. Anyone can basically say anything in an email. Could Brown be doing all of this because he knows that Lorianne is right about her being an agent for KJ? Could be. He's trying like hell to get that Lorianne declaration out. That's why I said, whoop, there it is. This whole thing has felt to me like gut response that he is doing everything he can to get rid of that Lorianne declaration because it is very damaging to the jurisdiction argument. Could Brown just sit down, calm down, and let Babs decide already? I mean, he feels he can't clearly he feels he can't. So it's just, he feels that he can't and he's not going to. I'm going to try. You guys, I am trying to get to questions as best I can. Thank you for being patient. I appreciate that. Law nerds. Let me know what it's at now. Thank you, Cindy. We can see if we can get it up a little bit. I use first names in business emails, but I don't usually communicate with clients. I would use first names with my colleagues sometimes, but not with opposing counsel where I've asked for sanctions. Like when you're contentious with opposing counsel, you tend to leave it a little bit more formal if you don't have that kind of relationship. But I can see why, it's Michael and Jeffrey, unless Jeff on the phone says, no, it's Jeff, it's fine. I don't know. Question, do you think he's trying the word salad method to try to confuse and frustrate research attorneys? He's not going to, though, because what research attorneys are going to do is pull out all of the statements the way that I keep pulling them out of my brain and go, but there was this, and there was this, and there was this, and there was this. That's literally what their fucking job is, and that's what they do. And they kind of live for this stuff. Like if I were a research attorney, this is juicy stuff. It's like, ooh, but there's this statement and there's this statement. I'd be annoyed by the 45-line paper. I would be annoyed by the going over motion length. I would be annoyed by the excessive amount of motions. But you would also be like, oh, but you said it was this. And then you said it was this. Like the going through and connecting the statements would be fun. Like it would be entertaining. Can Salty respond to the sanctions motion and this motion at the same time since he has time? Or could he use this motion to defend against that one? He can do. They can do kind of whatever they want. I would imagine that they will respond to one and then the other, unless the court issues a minute order between now and then. It's just that I have never seen anything like this. Amy Yost, isn't there an RPC rule about over litigating? Yup. Brown seems like he's desperately struggling to keep his head above water and arguing with himself. I don't. Again, this motion would have been better taken for me because I get where this motion is coming from. I understand the point of bringing this. I would not be mad at this motion. I would have had issues with some of the statements being like, I don't remember it was said that way. I don't see it that way. That's just a difference of opinion. He's going to argue his side. It's the sanction motions in connection with this motion that fucking kills me, because that's where you're arguing to the court actively, sanction this lawyer, take this huge punitive measure against opposing counsel because of this. And then in the next motion, that's not true. That's the thing that's killing me. If this motion stood alone, I would have a much different perspective of it. If this motion was standing alone, I'd be like, oh, Brown thinks that Saltz is trying to like end route around him tactically, and Brown's trying to put a stop to it. Understood. Let's walk through these arguments and take a look at them. I see where he's arguing that he doesn't represent Lorianne. It's hard for me given the other motion. That's just what it is. Regarding Brown's offer to stand up for Lori, what determines representation? The client's perspective. If Lori believed, there are a lot of rules about what creates an attorney-client relationship. And yes, some of it is perception. Some of it is what was intended. But yes, some of it is perception. Do you think there's much more going on behind the scenes than we're privy to? Absolutely. I feel like we're all missing a very important information. I do too. And yes, I'm sure there is. I don't know what else is going on between these attorneys, but we're going to find out, aren't we? Question, I was under the assumption that in the motion for sanctions, Brown was saying that Salty thought Brown represented Lori, not that he actually did. Or did he actually say he represented her? He said that Brown said that Saltz was speaking to a represented individual, but arguing that Saltz knew that she was represented. And so in that argument, he's arguing that she was represented, because even if it's not true, you can't get sanctions on it. So the way I took it is he's saying, look, his reasonable belief was this, though, again, it could have been Saltz's belief that when she cut off communication, she fired him. But for me, it's just not well taken that he's arguing both. And it could very well be that that's what he's trying to argue. Hannah, it could very well be that that's what Brown is trying to argue. It's going to be difficult for the court to go like, wait, you want sanctions over this because she was represented, and then you're saying she's not represented. That's my read on it. The court might take the other read on it. That's totally for sure. The court can do. Well, I don't know what the court's going to do with this. She might just haul everybody in and scream at them. What do you think Saltz will do in response to this? I think he'll probably respond to the other motion first and wonder why everybody's throwing money into a trash can and burning it. Have you ever seen such animosity between attorneys? Yes, but I did also see attorneys almost get into a fist fight in the hallway. And do you see any path for coming back from this? Nope. Looks like Brown is souring things with my boy Jeff since Saltz is already out. I don't even know how they negotiate at this point. I don't even know how they negotiate this case at this point. I don't. Thank you so much. All right, I'm going to sweep through some questions, and then I am going to have to twinkle time because it is getting late and there is family time. Is it possible that this was filed by two different aides under Brown's name and they didn't communicate, messages got crossed? Ooh, that would not go well, because in a firm, there is a case file. So you're not going to file something until you've reviewed the case file. Is it possible that two different associate attorneys worked on the things? Yes, totally possible. But they would both be obligated to know what's going on in the case and what's being argued in the case. This is fantastic. And I love the reference. Thank you. I feel the research attorney in this case has facepalmed so much their face is entirely flat now. It's totally possible that the research attorney is like, why? But also a little bit juicy. Like also like, ooh, people are fighting. Like this isn't normal. Like the same way that we're here being like, oh, what the fuck now? The research attorney is probably like, what the fuck now? Like every time, because the research attorney gets all of the information coming across, right? Because it's all digitally filed, is probably just like, no, not you again. When is your next mail time? I sent something needed for code red lights. Whenever I can get to the mail again. I did one on Instagram yesterday, but I have not been able to get back to my mailbox. Here from Houston, Texas, I'm so glad that you have power to watch this. Thank you for your kind words. That means more than you will ever know. Thank God for power, cell service, and water are back. I'm so glad to hear it. It's just heartbreaking. Like, none of us want to see our anyone like, I don't know anyone that wants to see other humans suffer. It's like after Katrina, when it was so heartbreaking just watching people not being able to do anything. It feels very similar to me. When were those emails to Jeff? Do the dates conflict with his filing of the let me look real quick. Let me see. The sanction motion was filed on the was it only the 16th? No, that was the minute order. That was the minute order. They were filed on the 10th. So the motion for sanctions were filed February 10th. And this last email was from February 4th. So the last, we're not doing this email was February 4th. So a few days before the sanctions. Question, can the Minnesota lawyer write the declarations and have Brown sign off on them? I don't know. There's no Minnesota lawyer that's appeared in this case. So Brown is the only attorney Brown and his firm are the only attorneys of record. So you wouldn't have a lawyer from another firm writing stuff for you if they weren't a lawyer on the case. That would be very unusual for me. But there's a firm there, so there could be multiple associate attorneys working on this case, multiple different associates working on this case. Question, whenever I've used my in front of a person's name, it's with two people with the same name, right? Is there a Katie that works for the opposing counsel? We've not seen anybody. We've seen on these things, Salty, Alana Levine, and Jeffrey Blanco. Those are the people that we've seen on all of these emails. And then on Brown's side, let me see. I've got these emails pulled up. Let me see who he's seeing. On Brown's side, it's from Brown to Blanco, Saltz, Alana Levine, and then Suki Kaplan, who is, I don't know, CBB legal, working with somebody else. Oh, with them, they're CBB. So his associate counsel is named Suki, or Suki, S-U-K-I. So no other, it doesn't look like any other Katie. My Katie is the very Silence of the Lambs. It's weird to me too, y'all. This must be costing KJ a fortune in fees. Yes. With motions coming fast and furious, I truly can't figure out. I can't either. And I brought it up, and I know some people took issue with the fact that I brought it up, but cost of litigation is something that has to be discussed. Like, cost of litigation is a real consideration in litigation strategy. And it's your obligation as an attorney to try to do things in the most streamlined way possible, and the most streamlined way to get to the point. And when I talked about the Keemstar lawsuit, that lawsuit, Keem got sued, fought back, and got paid because he won attorney's fees in under a year. Why? Because his attorneys were like, this is where we fight, and we're fighting just this. And I don't understand. Look, if you're Apple and Epic Games and Amazon and Facebook, I understand this, Facebook, you want to sue us? Oh, okay. You make billions of dollars. We make billions of dollars. Mount the fuck up. We're going to do this for 10 years. Let's ride. I understand it when it's $1 billion corporations. I don't understand it when it's civil litigation with essentially individuals. I don't understand it. I don't understand the trial strategy here of burn the boats, burn the cash, because at some point money runs out and we're still not even to the point yet. They haven't even answered the lawsuit yet. And I just can't perceive that this strategy is going to go well. Once the motion to dismiss is ruled on, then litigation begins. It either begins in Minnesota or it begins in Washington. But then there's answers, and then there's months and months and months of depositions, which can also cost hundreds of thousands of dollars to do. There's so much more to come. I don't understand burning money this early. Can we get a mom t-shirt? Mom! Yes, there will be more regular merch drops. We've got the team. We've got the team to do it. My Katie is very Golem speak. It does feel that way. My precious, my precious, my precious. I'm sorry, Marissa. Sometimes make sure you guys, if you're here, that you're still subscribed, because YouTube does that sometimes, that you have notifications set to all, and that if you're in North America, you're in the text crew at textemily.com. I have not forgotten to text the text crew at all. Yesterday's took a little bit to go out, but I text the text crew whenever I'm doing random things like this. It's like text the mods, ask if they can ride, and then text the text crew. So that is the thing. The YouTube things. Thank you, Octo. Claire, I don't know if the court will refuse to read the motions on 45-line paper. I'm surprised the court hasn't done another minute order reminding that there's a standing order, but there was 2 initial minute orders saying per the standing order, per the standing order. So at some point it's going to have to come up, or maybe the judge does not care. That's also possible. It's possible that it bugs me more. As a former research attorney, it bugs me. And then we got Brown's whole resume, and he's like, I was a former research attorney. Okay, well, read the standing order. How does the court decide what order to work cases in? Could it take a while for Babs to respond because of the order of cases? Sometimes it does depend on what's going on. I would imagine at this point, and I could be wrong, but I would imagine at this point the court will decide on jurisdiction and then deal with the rest of the stuff after. I do. I think she's just going to do that. Yes, it is almost twinkle twinkle time. It is. It is. On Wednesdays we wear pink. I appreciate that, Jojo. I love Mean Girls. It's such a good movie. I'm going to look for a few more questions and then we're going to go. Question, is this filing providing Saltz with more information for his response to the sanction filing? Maybe. Can the judge set all these filings aside, rule on jurisdiction, and then go back and pick up the rest? Yep, sure can. Yep, sure can. Question, why didn't Brown include excerpts from Lori Ann's unsigned declaration as evidence to back up his assertion that it didn't conflict with KJ's interests? Because it's not signed. Like, you can't give evidentiary value to it. Also, it's been submitted like 16 times, but it can't be relied on by the court. It's not a signed declaration. He's saying, look, she said something totally obvious. And the response is, but she didn't say it in court. It's not signed. Until somebody swears under oath or says it in a declaration, it's not said. It's not said. Oh, Jojo, thank you. Would KJ have to approve Brown filing all these extra motions, or can he do it without her permission? Every decision should go through the client. Like, hey, we need to do this and this is why. Hey, we want to do this and this is why. So yes, it should all go through the client. Even the decision to do everything should go through the client. Misty, look, you know how I have felt about the connection to these 2 cases from the very first video I did on these 2 cases. Something is off. There are other factors at play here. This litigation strategy does not make any sense to me, and the money burning of this litigation strategy does not make any sense to me. I would say something different if we were dealing with Apple versus, Facebook, or Facebook versus Apple. It just doesn't make sense to me. And that's not meant as disparagement to KJ. This type of litigation strategy wouldn't make sense for somebody making $2 or $3 million a year. This is a multi-million dollar litigation strategy, and it doesn't make sense to me for these parties. And it's probably also very frustrating to Tati because she has to keep up with the pace that's being pushed by defense here. And if the strategy is to try to run Tati out of money, why? And does KJ have the resources to run Tati out of money? I don't know. It's odd to me. It doesn't sit right with me. There is something there, and I don't know what the there is, but it's an odd litigation strategy. Just and yes, I mean, who knows? All the filing attached to the motion to dismiss are some separate. Oh no. These are separate. The motion for sanctions is a whole separate entity. This motion is a separate thing. The motion to dismiss encompasses all those precipes and all the declarations, but then there was also another motion for status conference, and that includes the Nat Kennett declaration and the hacking and threat information. That's all in that motion for status conference. So no, we've gone very far afield from the motion to dismiss. The motion for dismiss is done. None of this stuff is part of the motion to dismiss, though it relates to the motion to dismiss in so much that it relates to Lori-Ann and her declaration. This is true, Jesse. It is true. It just frustrates me. And it frustrates me. And I don't want to ever say or assume that that's what it is until it's proven. We're just going to see with this one. This might be the litigation strategy. I don't have to understand everyone's litigation strategy. My litigation brain works my litigation brain way. I'm not going to understand everybody's strategy. A lot of the times I can see where somebody's coming from and go, oh, I can see why they're doing this, or I can see why they're doing that. The money on this sits weird for me. KJ stated in a July video that she had no money for an attorney. Who could believe that she now has hundreds of thousands of dollars without help from an outside source? I don't know. What happens if you run out of money during litigation? You represent yourself in litigation. Thank you, Octonation. I know purple hair soon. I feel like I might understand these actions more if I knew their astrological signs. A. O'Brien, I love that so much. Does anyone know Brown or Salty's sign? No idea. Who has a stronger case right now for the defamation case? Ariella, we're not even there yet to evaluate the defamation case. I think some counts are very strong. I think other counts are more of a fight, but I cover that in my initial video about the defamation case. I think the defamation case is strongest as to James Westbrook at this point, for sure. All right. I lost things. I know I lost something. All right. I saw a super chat that I lost. I'm sorry. Let me see if I can pull it up this way. And then the mods are like, we're going. Oh, Jojo, thank you. Jojo, I was not meaning that to anyone here, obviously. Thank you. And then Snowcat Trish said for the upcoming movie version, Meryl Streep to play Emily and be narrator of the movie. Thank you. Casey, do you think KJ could be Swanson's daughter? I can't imagine there would be a relationship like that at some point. Safub said this case is running like Denny Crane is lead counsel for KJ. It's just it's odd. This case is odd. It's odd. That's it. It's odd. And there's stuff that just doesn't make sense. And I'm trying to make it make sense. And without all the information, which we're not going to have until some point in the future, we can't all make it make sense because we don't know why burn the money is the litigation strategy right now. But that seems to be the litigation strategy right now. Run to the court with everything, burn the money. And it might just be that Brown's like, I can't trust these people. And Salty is like, I can't trust him either. It's just, this case got very combative very, very quickly. But it came from both, like early came from both sides. Early on. It was like, ooh, we filed a Zillow printout and asked the court to take judicial notice that it was evidence. That happened early in this case. So we're still dealing with the fallout of it. And at some point the court's going to be like, I told you that I didn't want to go through emails to see who did what to who. And here we are going through emails to see who did what to who. Couldn't the strategy to make Tati regret the lawsuit and get her to settle, especially if the guy from the other lawsuit is paying for it? Ella Sky Blue, that could very well be the strategy. It could very well be the strategy. It's a big money strategy. And at some point, Halo Beauty is going to be paying for some of this. Halo's also a plaintiff in this case. So if Swanson's trying to regain his part of Halo, and is running them out of money, this is if God's of speculation, then what's left for Swanson to take at the end of his lawsuit? It doesn't make sense to me. Thank you all. It is totally twinkle twinkle time. Y'all, it's twinkle twinkle time. Hopefully that made sense. There are still 6,600 law nerds on here. If you have not liked or subscribed, please do the YouTubey things. You can follow me all over social media at the Emily D. Baker if you don't. I enjoy the Instagrams and the Twitters. I'm learning the Twitters better, but I'm at the Emily D. Baker all over the socials. Tomorrow night, I have a very special friend coming to chat with us about the business of being a creator. And my friend Scott has been a voice actor for everything from video games to movies to voicing commercials. He was in the Mighty Ducks. He was a lead on City Guys. There's a very, very interesting Slim Jim commercial that we made fun of him about in high school. There's a Pop-Tart commercial as well. He is a fascinating guy, also a musician, and has worked in the film industry for a very long time. So as we talk about SAG-AFTRA, the actors union, allowing in influencers to be part of the union, are they going to be eligible for SAG awards? We don't know yet. But as the union is opening up to allow TikTok influencers, Instagram influencers, YouTubers, and others, it'll be very interesting to see what a more traditional actor thinks of that, how he's worked with SAG in his profession, and just have conversations about, I'm going to ask, like, what was it like filming Mighty Ducks? And what is it like being a working and busy working voice actor? All of that stuff. So we are going to talk about all of that tomorrow night, which is why I really wanted to come on tonight. It was not my intention to go live. The mods were like, we've got you. Let's ride. So a huge thank you to the mods, because then we could talk about this tonight, get the information out there, answer your questions, take a first look, see what we thought. And tomorrow night, just, quack, 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 quack. I can't wait for that conversation tomorrow. So be back here 7 p.m. Follow me on the socials. I'd already told you to do all the things. You guys are the best. I appreciate all of you law nerds. Stay safe in this wild weather. I hope that you all get power, heat, water, and you're not boiling snow so you can flush your toilets, because that's just the fucking worst. So take care of yourselves, and I will see you tomorrow night right back here. Good night, everybody. Good night, good night, good night. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube